So I'm going to ask you again. On January the 26th of 2016, you're saying that when you swore under oath of office...
I asked and answered.
Okay.
We're not going to go through this again. Is there any more questions other than the ones you've already asked?
I think I've asked a question, did I ask the question about her what she wrote in the financial disclosure?
Yes.
Okay, and her answer was that she did. Okay.
That's correct.
So my next question is, she's saying that, are you saying then that you have paperwork?
George, if you have a question for me,
I'm trying.
you can't do argument, that's later. We'll get to there.
Okay.
Do you have any more questions?
No, I just had that one question about her documentation.
Just have a seat. Do you have any other evidence or testimony you wish to present?
I'll let my daughter come up and testify that she has ownership of the business, if you would like. Can I do that?
Yes, you may. Can you state your name before you hear your testimony? You're going to have to be sworn in too.
Ann Cruz. Ann Barr Cruz.
If you'll raise your right hand. Do you solemnly swear or affirm the testimony you are about to give in this matter should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
Okay. I ask for questions.
I don't
guess.
know how we do this,
You
but I
want
think
me
you
to-
can ask
okay,
her
I'll
questions and
ask
she
you
can answer.
At the end of the year, did you take over your 25% ownership of the business?
Yes. my
And at
sister.
the end of the year, did your sister take over her 25%?
Yes, we both took over our 25% interest in amusement construction and everything else.
All of them?
Yeah, everything else.
They're all interrelated, so they're.
Yes, but ACC, yes, we took 25% ownership. I got my quarter and my sister got her quarter.
Okay, that's all.
You'll stay there, Mr.
I'll
Rowe?
just stay here.
If you can ask questions,
I will ask a question.
you can
I'll ask a
ask
question.
questions of her, but no rebuttal, just
Okay, I'll ask the
questions.
question. So basically, the property was transferred to you at the end of 2015, correct? So it was still in your mother's hands or name or what have you before that, is that correct?
Yeah.
Okay, so when your mother wrote and that financial disclosure, that was correct, that she owned, okay. So the change occurred just before the meeting in January
The change took place at the end of 2015 to make them clean breaks for tax purposes.
right, and but just within a month of January the 26th of 2015, when is that correct?
Yes.
Okay.
I took ownership January 1st, and she ceased ownership December 31st.
Very good. So she was still the owner on December the 31st of 2015, about a month before the.
Correct.
That's my question.
Okay, any other questions?
I think I've asked all the questions. I think I've tried to establish that there is a recent ownership.
Yes or no? And you can sit down too.
Thank you.
Ms. Barr, do you have any other further testimony or witnesses that you would like to call?
I do have a question. Can I ask you a question?
I don't know.
Well, one part of it is, it has to do with, would the testimony include why I don't think I had a conflict?
She's supposed to present evidence in defense of the allegation.
I cannot answer that question. You are supposed to present evidence showing that you didn't do that. And if you present something and it gets out of line, this guy's going to grab me on the shoulder and tell me you got to tell you can't present something.
I can start, and he'll tell me to shut up if I need to. How's that?
Thank you, Earl.
Okay. The reason I do not feel I have a conflict is that the code says in section 264 that, 265, a city official shall disqualify himself or herself from participating in an official act or action study of the city which results in a pecuniary money benefit to the member or business or activity in which he or she has an interest or a substantial interest. At the time I made that vote, I would have no interest in the business, and at that time the vote was made, we had no dealings whatsoever with Mr. Hack.
Okay, is there any, I'm going to do this one. Is there any other testimony or witnesses that you wish to call in your defense at this time?
You don't want to come up? He doesn't want to come up, so no.
Are you resting your case?
Yes, I am.
Do you have a closing statement that you would like to make?
Do I go first?
Do you have a closing statement that you would like to make?
Okay, I go for him.
He's already made his closing statement.
Don't I have a right to ask her a question just then?
If it has to do with what she just said, but not any previously asked questions.
Okay. So you're saying that on December the 31st, you ceased ownership of this company?
Yes.
Okay. And you acknowledge that, I mean...
Questions, George?
Yeah, okay. Was he a client of yours for all those years, going back to 2005?
He was a client of my husband and his partner for those.
And when did he become a client of yours?
No, I actually do nothing in the business whatsoever. I actually have never gotten any money from the business, or a salary from the business, or anything. So if he, I did nothing.
My question
George,
was...
let her answer.
I'm trying to answer you. As to me having any interaction with him, I did not. All interaction came either from my husband or from my husband's partner, John. I never had any interaction with any contracts, any money dealings whatsoever.
I'm not asking that.
Okay, George,
So-
question?
I'm asking the
Just
question.
answer the question.
I'm asking the question, when did that come into your name?
It would come into my name when my husband passed away,
And when was that?
2012.
2012. So was Mr. Patton a client of yours starting in 2012?
He was a client of the company, yes.
But
But I had no contact with him.
did you have substantial interest in that company?
I did have an interest in that company.
Substantial.
Yes, I had a substantial interest in the company.
That's
Okay,
all
guys.
I asked you.
Okay.
Okay. And you maintained that substantial interest from when in 2012?
Until December 31st of 2015.
No. When in 2012 did you receive that interest?
After my husband passed away.
And when was that? The beginning of 2012, the middle?
June 28th.
28th of June, so 6 months and 2000, so you owned it for a couple of years, right?
Yeah.
You had substantial interest in it for a couple of years, right? And then you denied that a month after you gave the property to her.
George.
Is that correct?
No, I did not deny. I said that I did no business dealings. Me personally have never done.
That's not the question here. Were you an owner, substantial owner?
Yes, I was.
All right, then
I've answered that 10
I
times.
don't need to hear any of that other stuff.
Okay, George.
You stop.
Okay.
You ask questions,
I'm asking
she gives
questions.
answers.
Okay.
Ruth, when you ask a question, please answer the question.
Yes, sir.
Okay. So I guess I've asked the question that you had.
No, George, you don't go over all the questions, you just ask. If you have a fresh question, ask the fresh question, please.
I think that's my questions.
Okay, thank you, George. And thank you, Ruth.
Thank you.
You need to make a closing statement, if you wish to, and then we will close your case, and then we will move on to the next step.
At this closing statement, may I present my motion?
Yeah, we have to close the case first, I'm sorry. So
Oh,
we
then
need
I
to
can
make-
present the motion.
No, then George gets to cross-examine on something, and we'll go for the next step at a time, rather than me explain the 13 steps. Let's go one
Okay,
step
all
at a
right,
time.
that's fine. My closing statement is, at the time, I had no conflict of interest. As I stated, basically, it was in my name, but it was only in my name because it belonged to the children. At no time did I get any money whatsoever from any one of the businesses that are associated in the band. I've never received a salary or a profit sharing of any sort from any of them. And that's the end of my closing statement.
Okay, you can have a seat. George, do you have any evidence?
I'm my advocate, I'm asking a question. Excuse me.
Okay, George, do you have any evidence only pertaining to being able to rebut what Ms. Barr said, not
I
previously?
didn't hear exactly what she said. You know, she's facing here, so I didn't hear everything she said. I think, could you tell me what she said?
No.
Okay. She said, I believe I think she said she didn't receive any money from that.
Do you have rebuttal about?
Yeah, I do. I don't understand how that has anything to come into play here. First of all, she would have to present evidence, I think, that would show that she didn't receive any, and she hasn't presented that evidence. But besides, it's moot. It is moot because my closing statement is this. It doesn't make any difference. That's something that we can't substantiate, that she didn't receive any financial stuff from this. We can't substantiate that. She can't substantiate it. She didn't bring that information to this hearing. So my statement is, and what the code states, is a substantial interest existed on paper when she voted on the council meeting on January the 26th, which she just admitted, it was January the 26th, that she voted, that she did not have.
Yeah, you've already presented this. This is new stuff. Do you have anything else?
Oh, I was trying to, I thought I'd make a closing statement.
No, you did closing statements already. Do you have anything new that you want to rebut on what she said?
Okay, the only
Not stuff that you said previously.
The only thing that I have to rebut is that I understand that she needed to bring her stuff here 5 days beforehand too. She is coming with a denial verbally, but we don't have any evidence that...
George, just for clarification, the 5 days is on you, not on her.
Oh, okay.
Just so that you'll know that. I'm not trying to deny it, but
Okay.
you're the one that has to present the accused stuff to her, and then she gets to defend herself. She doesn't have to tell you what her defense is.
Okay. Basically then, my closing statement is that she had a conflict of interest.
George, you've already given a closing statement. My question to you is, do you have rebuttal evidence showing that the testimony that she just gave is false?
I don't have rebuttal evidence that the testimony she just that she didn't receive any money on that.
Thanks. All right. Just 1 second. We now understand that you have concluded your case, and board, you now have permission to ask anyone who presented questions that you want answered. So, and anyone who was sworn, which includes Ann Cruz. Only the sworn, I'm sorry. Okay. Mr. Brogan, Ms. Barr, or Ann Cruz are the only ones you can ask questions to, and you can ask them directly, and I will ask you guys when you answer the questions, please answer to us, not to each other. Only.
I have a question. So,
Who do you want to ask it to?
what's your name? I'm sorry.
Me? And
Ann, would you step up here,
Yeah,
please?
just so you can see it.
We're going to have each person, as we ask the question for clarification, stand up there so the conversation stays with us.
So you and your sister own 50%?
yes,
Who owns the other 50%?
our business, my father's, which was my father's business.
Oh, okay.
They were 50/50, and
Okay,
then
so the two of them.
when he
Okay.
passed away, we obtained
Took-
our half.
Okay. I just need to know who owns
Okay.
Any other questions for Ann? Okay. All right. Anybody got any questions from either of the other two? Because if you don't know where you're going with this, you need to ask the questions now. So I understand that the board has no further questions for any of the sworn witnesses, is that correct?
Correct.
Okay. So we will close the hearing and we will go into the part where we deliberate.
Now, you had said I could do motions after 9.
She's already made them. She might want you to know we can take written ones, one by
Yeah,
one.
you've already made them verbally, but if you want to enter them written, you can enter them one by one, and we can go back and do that part now to make sure everything
Yes,
is done.
thank you. Yes, sir. Okay, this was the motion having to do with the,
Please provide one to Mr. Rogan also.
this is the motion to dismiss due to the fact that the date was incorrect in the file. I ain't got to drink. Will we stop with that one? Do them all.
I think we're going to do it one at a time.
I'll sit
Yeah,
down.
just give us a second. Okay. Ruth,
Wait a minute, did I get a copy? Yeah.
I've been informed that you had already entered this orally,
Mhm.
and we're at the part of the meeting where we will deliberate on this, so it
Okay.
can't be entered in as a motion. Do you have another one?
Only motions I've done orally.
So at this point, then we may be able to move into the deliberation part, where we can start asking questions. Yeah, we can discuss it amongst ourselves. Anybody who's deliberating, make sure your mic is on. Debbie? You're on there. We all heard you cough.
Thank you. Now we know it's not my
Now we know it's
test.
working. Okay.
You had a second?
Okay, the first thing we're going to discuss in deliberation is if the board has decided by majority vote that additional evidence is needed to make a decision. The board shall have the authority to conduct its own investigation or require that either complainant or respondent, subject to the respondent's rights against self-incrimination unless the same is waived by the respondent to submit additional evidence. So now what we need to talk about is do we have enough, and can we take the sworn testimony? Or-
So I can't tell you what exactly all you have before you right now to think about on this question is whether or not the evidence that the parties presented is sufficient for you to determine whether or not this ordinance was violated as complained and all the rest of it.
So now we have to decide whether there's enough evidence here to make a ruling. Okay. Each of you make that statement louder.
I think we have enough evidence to make a ruling.
I feel we have enough evidence to make it.
I believe we have enough evidence to make a ruling.
I think we have enough evidence to make a ruling.
But to a majority vote, the question as to whether, help me state this, because I want to make sure I stated it the right way, whether there was a violation or not.
Okay, so the board is going to now decide on your vote
Anybody who believes there is not enough evidence to make a ruling, please raise your hand and say aye. All of those who believe there is enough evidence to make a ruling, raise their hand and say aye.
Aye.
So now we need to discuss and deliberate whether we believe that Ms. Barr violated the code of ethics as registered by George in the complaint. So explain and talk about what you have here.
The biggest thing I'm looking at is,
Say it in your mic because everybody's got to hear it.
I'm just gonna put it this way, I want to speak to the team. The fact that she owned the business for 2.5 years after the death of her husband. And then how long before you go before the board, you get notification for alcohol approval? How long is that process?
I don't know the answer. I served on the alcohol review board, but I don't know. But I don't know if that's one of the questions.
You're only basing on the evidence.
Yeah, you're only based on the evidence that we have here. We've already ruled we have enough evidence, so we can't seek more evidence now.
Well, I thought we were talking a month.
But, yeah, but it's got to be
It
based
really
on.
doesn't have anything to do with,
With the, to
No,
my
the evidence
understanding, and
we have.
I'll quote what I think I understand, but I get out of line, you can tell me. What I understand is George made the complaint that on, according to the complaint, next week, Ruth made, but Ruth has already clarified, it was a January 26th statement.
Right.
But she sold, she was the executor of the estate and had it until the end of the year where the clean break was made, and so that it went to them. So she, I understand from what I've heard, that she did not own the business on the 26th. And so,
On the 26th of what she?
January
January
26th.
16th.
She owned the business on December 31st.
Right.
2015. I don't know how long it takes to do that, but I know when my mom died, it took us like 22 months to get, my sister was the executor, and it took 22 months to get everything paid up and stuff like that. So it doesn't happen in 30 days. So
Okay, but
George basically said,
she owned the business.
she owned the business.
For 2.5 years.
No. What he said in the complaint was, she owned the business when she made this decision on January 26th. Ruth has said she didn't own the business on January 26th. She owned it until December 31st,
Right.
26 days before that. But she also said in testimony that she didn't take any money. And I know, I wish I'd have thought of it. I've got a question I wish I'd have asked, but I can't now. But so she didn't own the business when that was made. George's complaint is she owned the business. His complaint is that on September 18th, did she own the business? And yes, she did. On December 31st of 2015, the business was transferred into her two daughters' names. On January 26th, she would not recuse herself because the accusation was made that she owned the business, but she didn't at that point. So we have to decide whether or not an ethics violation took place or not. Is that pretty much, do I need to make any more statements of that fact? Do you all have a grasp of that?
Yes.
Do you have any more comments? Do we vote to close the comment section, or do I just call the question? All right, so I need to call the vote on whether or not the respondent, Ruth Barr, violated the ethics code as charged by the complainant, George Rosen. So all of those that believe she did not violate the code of ethics, raise your right hand and say aye.
Aye.
Those that believe she did violate the code of ethics, raise their right hand and say aye.
Aye.
So it's a 3-1 vote.
It's done.
At this time, the hearing is closed, and we have ruled that Ruth Barr did not violate the code of ethics according to the complaint registered by George Rosen. Thank you very much.
It's not going to be a
Okay, excuse me, we're going to make one more motion.